Hey everybody, welcome back to the channel. My name is George Herrera with the Queens Home team at Keller Williams Realty. In today's video, I'm answering a question that's fairly common for any individuals who inherit a property. So this question comes up pretty much on occasion for us every year, where we get people who have inherited a property and they wonder, do they have to go through probate? So this is the question. I inherited a home. Do I have to go through probate? Inheriting a home, obviously someone passed away and then the next of kin or the heirs inherit the property. So the question is, do you have to go through the probate process? And the short answer to that is yes. Most of the time you do have to go through probate. The times when you wouldn't go through probate is if let's say a house was in a trust. So if it was in a trust, then you wouldn't have to go through probate, or if your name was already on the deed. So if someone put your name on the deed, let's say a parent putting their child's name onto the deed before they pass away, and then they pass away, and if it's joint tenants with right of survivorship, most likely that it just transfers over. So then administration or a probate proceeding is not necessary. So if it's in a trust, no probate. If the name was already on the deed, then you wouldn't have to do probate. But for most people, the reason they ask this is because their name isn't on the deed, and usually there isn't a trust formed and the house isn't in a trust. So in that situation, somebody passes away, they own the house, and the next of kin, let's say the children, inherit the property. Do they have to go through probate? So yes, you would have to go through probate there. And so just for more insight, I want to give the definition of the probate proceeding and also administration, because they're two different ones, and it helps to understand the difference in case you're in this situation. So what is probate? Probate is the legal process for reviewing the assets of a deceased person and determining inheritors. So it's one thing is if let's say the person had a will, and in the will it states who inherits the property. So you have that, but the probate process is the legal process of validating that will and validating who inherits the property. So you could inherit it based on the will, but you don't have the legal right to actually sell it or take any action. You're not the legal owner yet. The probate process is what actually gives the legal right to the property. So probate is the legal process for reviewing the assets of the deceased person and determining the inheritors. Probate proceedings typically focus on the existence, authenticity, and validity of the will. So it's a process of validating the actual will that was left. So again, this is if the person who deceased left a will. Probate can be initiated with or without a will. So that's where they're two different things. So if the person who passed away left a will, then the process is called probate. So probating the will is the legal process that you go through. Now, if the person passed away without a will, then that's called an administration proceeding. So they're pretty much the similar process, but just different depending on whether the deceased person left a will or whether they didn't leave a will. So here's just a little more details. So when a person passes away with a will, who inherits depends on whether there's a will and who the living relatives are and their relationship to the person who passed away. When the person who passed away had a will, then the will must be filed in the surrogate's court, which we have the Queen Surrogate's Court. Every county has their own, and it must be approved for probate. Probate is the process of proving that the will is valid, so meaning that it's legally acceptable. And during probate, the will must be proved to the satisfaction of the court that it is the last will and testament of the person who passed away. Once the judge of the surrogate's court is convinced that the will is legally acceptable, then an executor is named. So when you go through probate, the person who becomes the decision maker is the executor, and if there was no will in an administration proceeding, then it's called an administrator. That's the person who gets named as the decision maker. So executor for a probate and administrator for the administration proceeding. So once the judge is convinced that the will is legally acceptable, the executor is named in the will. or the executor named in the will is appointed to give out the estate that belonged to the person who passed away and carry out the wishes of the person who passed away. If the descendant passed away without a will, then an administration proceeding should be filed. That's also done with the surrogate's court. So again, that's also a legal process. So it's the same process, but if there was no will, it's called an administration proceeding. And then the person, once the judge approves the administration, then they give out letters of administration and they name an administrator. And the administrator is the one who carries out who distributes the assets of the person who passed away. Letters of administration appoints a descendant's distributee or the heir and gives them the authority to gather and give out the descendant's property according to the law. So that's the difference. The will actually states who the person who passed away wanted to be the executor, who the heirs are, who will receive proceeds, let's say from a sale of real estate. And administration, there is no will, so they go by the law, and that's how they determine who are the rightful heirs to, let's say, a piece of property. So that's the answer there. So if you inherit a property, unless the house was in a trust, unless your name was already on the deed, chances are you would have to go through probate. Something important also to note, if the person who passed away lived out of state but owned a property here in New York, you would need to do the probate process in New York as well. Even if you already went through probate in another state, you would need to do a probate process here in New York too. But regardless of the fact, if you inherit a property, there is a legal process. So one thing is the will, or let's say if there was no will and you are the next of kin, the heir, and you inherited it, but the legal process of transferring that ownership and giving you the right to take any actions with the property is the probate process if there was a will, and administration proceeding if there was no will. It always helps here. You can do it yourself, but actually it always helps to get a good probate attorney that can guide you through this process. So if you ever need any recommendations to a good probate attorney, feel free to reach out to us. We have a few that we work with that we know and trust, and we know that they do a really good job. So hopefully that answers that question if you had any interest in it. If you have any questions related to this topic, feel free to drop them in the comments below. And if you have any other topics that you'd like us to cover on the channel, you can drop them in the comments, or you can send us an email to info@queenshometeam.com. Thanks as always for tuning in, y'all. Take care. Have a great day.